Imagine a hypothetical business, Greenco Limited. On Monday, it's trading normally. On Tuesday, its financial foundation shatters, and it plunges into sudden insolvency. For the suppliers, lenders, and customers owed money, panic sets in immediately. That panic is justified by the Insolvency Act 1986, which forces all creditors into a strict hierarchy. This flowchart shows how the law prioritizes payouts. At the top are secured creditors, like banks holding a charge. Below them sit preferential creditors. At the very bottom is the massive pool of unsecured creditors, governed by Pari Passu. Because the upper tiers drained the assets, they receive a tiny proportional fraction. For standard suppliers, emergency lenders, and everyday customers trapped in that pool, Pari Passu is a financial death sentence. By the time the math is settled, they are almost guaranteed to face a total loss. But what if a party trapped in that bottom tier could prove they aren't actually a creditor at all? This is where the law of equity intervenes in commercial transactions. If a party can establish that the insolvent company held specific property on trust for them, they gain a proprietary right. They claim the actual property itself, completely removing it from the insolvent estate and bypassing the statutory queue entirely. This matrix outlines the three primary pathways commercial actors use to build these equitable lifeboats. We will examine customer prepayments, Quistclose lenders, and supplier retention of title clauses. Testing these three exceptions against strict legal doctrine is how the courts maintain balance in corporate insolvency. Mastering them is the definitive test of understanding commercial equity. We start with everyday customers. When you pay in advance for goods or services, like a mail order purchase or a holiday deposit, and the company goes into liquidation before delivery, you become an unsecured creditor. Can a failing company intentionally declare a trust to protect those consumer prepayments? In the 1975 case of Re Ford, a mail order company realized it was in financial trouble. On the advice of their accountants, the directors started placing all new customer payments into a separate bank account, specifically designated as a customer trust deposit account. When the company inevitably went into liquidation, Justice McGarry ruled that an express trust had been created. The company did not need to use the word trust with the customers. The physical act of segregating money into a separate account was sufficient conduct to demonstrate certainty of intention. Because the funds were segregated, the customers held a proprietary claim. The money in that specific account was held on trust, fully insulated from general creditors. Compare that success to the failure in Re Goldcorp exchange. Here, customers paid in advance to purchase physical gold and precious metals, which the company promised to store for them. Look at this inventory of gold bars. The customers each received a certificate showing how much bullion they owned. But Goldcorp never earmarked specific ingots for specific individuals. The gold sat in a constantly changing general warehouse stock that the company freely dealt with. When Goldcorp went into receivership, the customers' trust claims failed. The Privy Council determined there was no certainty of subject matter. Without identifying exactly which gold belonged to which customer, no trust could exist. Even if a company segregates funds perfectly, they face a strict statutory hurdle under Section 239 of the Insolvency Act 1986. If a company tries to put an existing creditor into a better position right before insolvency, it is considered an unlawful preference. In Re Fairpack, a Christmas savings company executed a trust deed to ring-fence customer money just days before liquidation. The court held that for customers whose money was already in the company's bank account, they were already unsecured creditors. Upgrading them to trust beneficiaries at the final hour was an unlawful preference, rendering the trust void. Here's the rule for your exams. To establish a valid customer trust, the mechanism must physically segregate the property before the transaction completes, preventing the customer from ever becoming an ordinary creditor in the first place. The second claimant class involves lenders attempting to shield emergency corporate rescue funds from general liquidation. Under the default common law rule, when you lend money to a company, ownership of the cash passes immediately to the borrower. You are left with a mere contractual right to repayment, a debt. But what if the money is advanced for one singular exclusive purpose? This node map illustrates the 1970 case of Barclays Bank v. Quistclose Investments. Quistclose lent over £200,000 to Rolls-Razor, strictly on the condition that the money be used only to pay specific dividends to shareholders. Rolls-Razor went into liquidation before the dividends were paid. Lord Wilberforce determined that because the loan was exclusively for paying dividends, the money was never at the free disposal of the borrower. This lack of free disposal created a trust relationship. Wilberforce held that there was a primary trust to pay the dividends. When insolvency made that purpose impossible, a secondary trust arose. The funds reverted entirely to Quistclose, keeping them safely out of Barclays Bank's reach. While the Quistclose ruling provides the remedy, examiners demand you understand the modern theoretical framework established later in Twin Sector v. Yardley. Lord Millett pointed out an analytical flaw in Wilberforce's two-tier model. If there is a primary trust for a purpose and the secondary trust for the lender if it fails, where exactly does the beneficial interest live while the money is waiting to be spent? It cannot exist in a vacuum. Millett solved this by categorizing the arrangement not as a two-tier trust, but as a standard resulting trust. This graphic shows the mechanics of Millett's resulting trust. The beneficial interest never leaves the lender. The money remains the property of the lender throughout. The borrower merely holds the funds subject to a restrictive power, a mandate to apply the money only for the stated purpose. High-scoring exam answers do not state the equitable interest is in suspense. You must apply Lord Millett's framework, proving the lender retains continuous beneficial ownership until the exact moment the money is applied as directed. The final claimant class relies on contract law. Business-to-business suppliers routinely deliver raw materials on credit, risking total loss if the buyer goes bankrupt before paying. To bypass the insolvency queue, sellers use Section 19 of the Sale of Goods Act 1979, which allows parties to explicitly state when legal title passes. By drafting a retention of title clause, the seller stipulates they retain legal ownership until the invoice is paid in full. This image illustrates the raw materials from the 1976 Romalpa case. A supplier sold aluminum foil protected by a retention of title clause. Because the buyer went insolvent while holding large stocks of unused, clearly identifiable foil, the supplier simply exercised their retained ownership and took the physical foil back. The Court of Appeal held that because the buyer acted as a fiduciary agent, the supplier could even trace their retained title directly into the cash proceeds of the foil the buyer had already sold. But retention clauses have a severe limitation, exposed in Borden v. Scottish Timber. What happens when the supplied materials are consumed in a manufacturing process? Borden supplied resin to a chipboard manufacturer, protected by a retention of title clause. However, to make the chipboard, the buyer mixing the resin with hardeners and wax emulsion. The Court of Appeal ruled against the supplier. Once the resin was mixed into the new product, it ceased to exist as a distinct asset. When the physical identity of the property was destroyed, the supplier's beneficial ownership was instantly extinguished. Equity refuses to act as an insurance policy for defective commercial contracts. If the asset loses its identifiable form, the proprietary claim dies with it, and the supplier falls right back into the unsecured pool. Whether you are a customer segregating prepayments, a Quistclose lender restricting loan usage, or a supplier retaining title, the core conceptual logic is identical. Success depends entirely on proving the asset was never at the free disposal of the insolvent entity. By proving the insolvent company held the property on trust, or never held title to begin with, these parties enforce proprietary rights. They successfully subvert the statutory hierarchy, legally removing their assets before the liquidator can distribute them. This creates a severe policy tension. The courts want to support emergency commercial rescue loans and protect naive consumers, but they are simultaneously hostile towards secret, unregistered trusts that blindside ordinary trade creditors who relied on the company's apparent wealth. Recognizing which side of this policy line a specific fact pattern falls on is the exact skill you need. Master the boundaries of these three exceptions, and you can confidently navigate the equity exam.